is shorthand for the purpose of the hearing today, owned a twin-engine Cessna business jet. Servicios agreed to sell the aircraft to a company called CoolPro, subject to a pre-purchase inspection. CoolPro, as the buyer, selected North Texas, the defendant, which is an aviation maintenance business located at the Addison Airport, to perform the pre-purchase inspection and agreed to pay for the inspection. Servicios agreed to allow North Texas to perform the inspection for CoolPro and had the aircraft delivered to North Texas. On February 26, 2020, after North Texas had performed the inspection, but while the aircraft was still located at the North Texas facility, North Texas shop foreman David Reynolds backed an aircraft tug into Servicios' aircraft while towing another aircraft. The North Texas tug punctured Servicios' aircraft's skin and damaged the nose rib assembly, radome bulkhead, and nose skin. It took 160 days to repair the damage to the aircraft. All of these facts are uncontroverted. All of these facts, we contend, support the claim Servicios has asserted against North Texas in the alternative, including breach of contract, negligence, breach of implied warranty, and bailment. Accordingly, in May 2023, Servicios sought partial summary judgment as to North Texas liability. While I was not present at the hearing on Servicios' first motion for partial summary judgment, it is my understanding that North Texas argued that there was a fact issue as to whether David Reynolds was acting in the course and scope of his employment with North Texas when he backed North Texas tug into Servicios' aircraft. The court denied Servicios' original motion for partial summary judgment. Thereafter, the parties conducted additional written discovery, and Servicios deposed North Texas corporate representative Stephen Erickson. Through Mr. Erickson's testimony and North Texas written discovery responses, North Texas has confirmed exactly what Servicios originally represented to the court, that North Texas shop foreman David Reynolds damaged Servicios' aircraft when he backed an aircraft tug into the aircraft on February 26, 2020, while moving another aircraft. This is depicted, for instance, on pages 64 and 65 and page 79 of Mr. Erickson's deposition testimony, which both parties have submitted in whole or in part to the court with their various filings on this matter. To date, North Texas has insisted on lengthy and expensive litigation of issues which we believe are not actually in dispute, such as, was David Reynolds in the course and scope of his employment? The answer to that question is yes. Was Roberto Reyes designated as a person with knowledge of relevant facts? Yes, indeed, North Texas designated him back in 2022. Was there a contract for North Texas to inspect the aircraft? Yes. Why else would North Texas actually perform the inspection? Further, North Texas arguments regarding implied warranty and the economic loss rule both presuppose the existence of such a contract. Was the aircraft in North Texas possession when North Texas employee David Reynolds backed a tug into it? Yes, it was delivered to North Texas for the inspection North Texas actually performed and had not been picked up yet. Further, even if the aircraft had been moved to some other part of the airport, which it had not, that would not absolve North Texas from driving a tug into the aircraft. In reality, Your Honor, there are very few disputed issues in this case, which is a relatively simple case. One would be, can a plaintiff recover loss of use damages even if it elects not to procure a replacement during the period of loss of use? The case law that we have cited in our response to Servicios's motion in response to North Texas' motion for summary judgment makes it clear that the answer to that question is yes. Additionally, another disputed issue in the case: what is the amount of damages Servicios suffered because of North Texas employee David Reynolds backing a tug into it? Servicios acknowledges that that is a fact question and requests that that issue alone be tried, and that North Texas liability be ruled upon by the court by partial summary judgment, so that we can try the issue of damages alone when the case goes to trial in October.
Ross?
Yes, Your Honor, and we have our own motion for summary judgment, which obviously overlaps with a response. As an initial matter, we also filed objections and motion to strike their affidavit of Mr. Reyes. Mr. Coates presents this idea that a lot of these facts are uncontroverted. That's just not true. That's simply not true. And the reason we're striking Mr. Reyes's affidavit attached to their motion for summary judgment along with their response is Mr. Reyes was never disclosed as a person with knowledge with this information. Plaintiffs served their initial disclosures yesterday. And in terms of their expert disclosures, which essentially that's who we're okay with, that's the list of people you guys think know something about this, Mr. Reyes was not on that list. So all of a sudden we roll into summary judgment and they attach this affidavit from this gentleman who allegedly has all this information for the first time. That's not how this works. You have to disclose who these people are so they can be deposed. This case was supposed to go to trial at the end of this month under our last trial setting. Now, we agreed to move it to October to have this hearing heard, but it was not so they could come up with some brand new witness with knowledge that we had never heard of before. Now, it did come up in their corporate rep deposition that Mr. Reyes had flown on the aircraft. I knew there was a gentleman by the name of Roberto Reyes. I didn't know he had all this alleged information on this incident, their damages, and he didn't serve as their corporate rep. That was a completely different gentleman. And so for those reasons alone, we think that this affidavit that they've attached to their motion for summary judgment and to their response should be struck. But even if you were to consider this affidavit saying, okay, well, you know about him now, you can depose him if we don't, depending on the results of this hearing. There are other big problems with this affidavit, such as he doesn't have personal knowledge of a lot of the things that are contained in there. And then also some of those things are directly contradicted by other testimony from, in fact, plaintiff's own corporate representative. For example, Mr. Reyes tries to say that, plaintiff, Coolpro, who was purchasing the aircraft, and defendant all agreed that defendant was going to do this pre-buy inspection. Well, plaintiff never had any direct contact with anyone from defendant's office. So for Mr. Reyes to come in and say, oh, well, I know what you agreed to, is not true. He didn't have any contact with them at all. And so that's not personal knowledge right there. And then on top of it, he says that the aircraft was delivered to defendant. He wasn't there. The corporate rep testified that the only person there was a gentleman by the name of Sean Denning. So for Mr. Reyes to come in and say, oh, I have all this personal knowledge, here's what happened, it's just factually incorrect, and it's not what their own corporate representative testified to. And on that point, Mr. Reyes in his affidavits comes in and he says, well, we sustained this big grand loss of use claim. Well, that's actually not what their corporate representative said. They didn't have to do anything in terms of loss of use. They didn't have to charter another aircraft. They didn't lease another aircraft. They didn't even buy an American Airlines ticket to go somewhere else. There was no reason for them to have any loss of use. And I'll get into why that's important and why Texas courts really don't allow what they're trying to recover in this case if we get to the substance of the motion. But plaintiff also says in their affidavit that plaintiff was not responsible for paying for this pre-purchase inspection, and that's included in Mr. Reyes's affidavit. But if you look at their own petition in this lawsuit, they say that the reason they have a breach of contract claim is because they did pay for this inspection. So we just have a lot of information across the board when you look at Mr. Reyes's affidavit that is completely different from either the record of this case, their own corporate rep deposition, or their own pleadings. And for that reason, we are objecting to the use of that affidavit in summary judgment evidence, and we are moving to strike it on those grounds. And then depending on your ruling on that, I can proceed to the response / defendant's own motion for summary judgment.
Your Honor, may I respond to the motion to strike?
Sure. You may.
Your Honor, Mr. Reyes was designated as a person with knowledge of relevant facts by North Texas in 2022. Additionally, the Servicio's corporate rep testified during his deposition at length about Mr. Reyes's involvement with Servicios. There is no surprise Mr. Reyes has been known as an owner and corporate representative of Servicios from the very beginning. So the notion that North Texas did not know about Mr. Reyes or his involvement with Servicios until we filed this most recent motion is simply not true. In fact, Mr. Reyes's affidavit supported the original motion for partial summary judgment, which Servicios filed in 2023, in May of 2023. Again, attesting to similar facts, if North Texas desired to depose Mr. Reyes, it certainly could have done so upon receipt of his 2023 affidavit. It certainly could have done so anytime since 2022 when North Texas itself designated him as a person with knowledge of relevant facts. It certainly could have done so after the Servicios corporate rep gave his deposition last September. So there is absolutely no surprise. What we hear in the argument about Mr. Reyes, none of the argument about Mr. Reyes's affidavit refutes what Mr. Reyes has to say. Mr. Reyes is an owner of the company. The aircraft was delivered to North Texas for the inspection that Cool Pro requests. No one contests that. It was there. It was at North Texas facility when it was damaged by North Texas employee. To say that somehow Mr. Reyes wasn't personally on the airplane when it was taken to North Texas in no way undermines.
The motion to strike is denied. Clarify that.
Yes, Your Honor, would you like me to proceed with the response to the substance
Sure,
of the
go
motion? Sure. So looking at the substance of the motion itself, and as Mr. Coates identified, they've asserted a lot of causes of action here, starting with breach of contract. For breach of contract, we all know the first question is there a valid contract? That is question number one. Our corporate representative from defendant said he didn't have any contract with Cool Pro. He didn't have any contract with Plaintiff.
But your client employee was driving the vehicle that struck the airplane, correct?
That is true, but that happened 2 or 3 weeks after we finished our work on it. And here's the killer. Here's the kill shot here. We were never paid for that. There's no consideration there. And their argument that, oh, well, we didn't have to pay, that was supposed to be Cool Pro who pays, it doesn't matter. There has to be consideration for there to be a valid contract. I mean, we can go back to law school to learn about that concept. And we filed a no evidence motion for summary judgment saying that, you know, there's no consideration here. In response, under a no evidence motion for summary judgment, they need to come forward and put a scintilla of evidence of consideration. If you search their response, there is no reference to the term consideration. In fact, they leave it out of their briefing, I guess trying to ignore it, but you can't win on a breach of contract claim without having a valid contract.
Explain to me a little bit. So your client, so the airplane was being stored there, it was being, and then this vehicle struck the airplane. This was after all the work had been finished. Is that what you're saying?
We did not agree. There's no evidence of an agreement to store the aircraft for an undetermined amount of time.
I'm sorry. So to repair the aircraft.
Not to repair it, to do a limited scope inspection. So basically what had happened was plaintiff entered into this aircraft purchase agreement with Cool Pro.
Right.
They said in their contract that we are not a party to it. They said, okay, this limited scope inspection is going to be performed.
Let me just say this, Mr. Coates, what this really feels like, and I think what this really is is a negligence case. They accidentally ran into your, I don't know how this is a breach of contract or a breach of warranty. It seems like this is just a garden variety. It's unusual that it's a vehicle hitting an airplane, but it's like if there was two cars in a parking lot, one car hit the other car, and there were damages, you would cover that under negligence, not breach of contract. Was there a contract between plaintiff and defendant?
Your Honor, we contend there was. We contend that there was an implied contract, an agreement between all three parties, Cool Pro, Servicios, and North Texas, for North Texas to perform this pre-purchase inspection on Servicios's aircraft. The agreement was for Cool Pro to pay Servicios for that pre-purchase inspection that Cool Pro sought. So it was a three-party contract. And the thing that's interesting about the implied contract is that other than the fact that Servicios now says, or excuse me, that North Texas now says
Who did your client pay for the inspection?
it was never asked to pay for the inspection. It was asked to deliver the aircraft to North Texas so Cool Pro could pay North Texas for the inspection. And what proves that is the fact that North Texas actually did the inspection. Had they not done, if there was no agreement to do the inspection, why did they do the
But
inspection?
the inspection was done weeks earlier, right?
I think it was actually done days earlier, Your Honor. I don't know the
Your Honor,
exact.
it was weeks. We finished the inspection in early February. This incident didn't occur until the end of February. And that was because plaintiff was deregistering the aircraft. Plaintiff is a Mexican entity, and they were having trouble or issues deregistering it as a part of the sale. So they just left it at our facility for weeks, at which time eventually this incident happens. Our corporate representative testified he did not see this aircraft as in our possession and control, and that it was simply in our way when this happened. For what it's worth. I mean, there's no contract without consideration. There's no contract when our guy says, we didn't have one. And they can contend this all they want, but at this point in the game, they have to put
Clearly,
forth
your client had a
evidence.
contract with somebody. They're not doing the inspection of the goodness of their own part, right? So,
Well, at this point they are, because they were never paid.
Okay,
Thus,
well,
there's no contract.
well, initially there was an agreement to be paid by somebody, right?
I would look to the record for evidence of that, except that's not where we are. And they haven't argued a third-party beneficiary of a contract. That's not what they've argued. That's not what they've pled, and that's not what they've briefed here for this motion for summary judgment. Is that a potential argument? Maybe, but it's not what's here today.
All right, so this is the defendant's motion. Defendant's motion is, you have a motion for summary judgment.
Yes, Your Honor, we're the defendant. We have a motion for summary judgment.
I'm sorry. Mr. Coates's client's motion for summary judgment is you have a motion.
Yes, Your Honor.
Maybe for summary judgment on.
For all of our causes of action, most specifically, what I'd like to point out to the court is that the aircraft was fully repaired, 100%. We had the repairs done by
It
Textron.
doesn't give your client a right to run into it.
I'm not going to make a comment on that, but what it does do is we have to look at what is recoverable under a loss of use standard. Now, there are cases under Texas law that say, hey, you don't have to actually incur the loss of use to be entitled to it. That's true. But what you can't do is come up with, I'm going to use this as a way to turn it into punitive damages. And that's what plaintiff has done here. What they are submitting is, we didn't actually incur anything. They didn't pay a cent for their loss of use claim. But what they're submitting to us is that we should pay $48,000 a month for an aircraft they were never going to use. They didn't lease a substitute, but we should pay $48,000 a month for this aircraft they would never use. That's also not typically how this is done in a case like this.
So let's break this down. Which causes of action are you moving for summary judgment?
We're moving for summary judgment on all of them. Breach of contract,
In order. Breach of contract, granted.
Breach of express warranty,
Granted,
breach of implied warranty.
granted,
Next was negligence,
denied.
and they also have a negligent undertaking cause of action in there as well, I think is how they phrased it.
Okay, let's hear argument, then I'll try to understand.
And I'll look at it too. So they're trying to say that North Texas, agreed to perform services and it knew or should have known that these are for plaintiff's protection. We didn't even know who plaintiff was. We didn't know we were contracting with them, or we didn't know what plaintiff's role in this was. It's also saying that we failed to exercise reasonable care in performing those services. Again, when it comes to the inspection that was done, there's no evidence that we did a bad inspection. The aircraft just sat for a while and then this incident happened, but the inspection itself was done correctly, and I don't know that there's any evidence to say otherwise. And so for those reasons, it's also saying that plaintiff relied on North Texas's performance, and North Texas's performance increased plaintiff's risk of harm. There's just no evidence of that. We didn't increase their risk of harm. They didn't sustain any harm. None of this really matches up. And so I also don't know that they produced any evidence.
Are you still arguing about negligent undertaking or another issue?
Excuse me?
Are you still arguing about negligent?
That was a negligent undertaking.
Okay, let me hear a response on negligent undertaking.
Your Honor, I believe that negligent undertaking would be subsumed in part of the negligence claim.
Right, so we have a negligence claim. That's what we've got. Anything else today, guys?
Bailment, Your Honor.
Bailment is denied. So you're going to trial on, if you don't settle this, on negligence and bailment. All right, give me an order on that, Mr. Coates.
Yes, Your Honor.
Make sure that it says that this was heard in a hybrid hearing on July 19th. And it goes through all of the different summary judgments on both sides. Share that with opposing counsel. Make sure that you get this to me by Wednesday, and try to get me an agreed as before. Okay, guys?
Yes,
Sorry you
Your
had to wait around. I hope you guys had a great time here in the cafeteria, and you guys have a great rest of your day, okay?
Thank you, Your Honor. You too.
All righty. Law school, see, first year law school.
It comes up every time.
It does, all right. All right, you guys are up next. Sorry for the wait. And our next case here is Breedlove versus Sonic. Your parent.
Dustin Brown here for the plaintiff.
And Shabazz Nizami here for defendant Sonic.
All right, I've read everything. Make your argument.
Judge, this is defendant's motion for summary judgment on the issue of statute of limitations. I will first go through the timeline so that way the court is aware where all this is headed. And this is undisputed as well, Your Honor.
Due diligence argument, right?
That is correct, Your Honor. The date of this incident occurred on December 22nd, 2021. This is a slip and fall incident, so it's a personal injury cause of action. Plaintiff filed suit on December 14th, 2023, which was 9 days before the statute was set to expire. On they also requested citation that very same day, so all is good at that point. On December 18th, 2023, the Dallas County Clerk's Office issued a citation and emailed it to the plaintiff of record, Mr. Dustin Brown. And then the statute ran on December 23rd, 2023. However, Your Honor, the defendant was not served until February 27th, 2024. So we're talking well over 40 days, maybe even more than that, since the statute had run and when the lawsuit was filed. Now, plaintiff's response says that they got the citation. It was in the email box of plaintiff's counsel on December 18th, 2023. And then when they found out on January 19th, 2024, which is about 32 days after the citation had been issued, that's when they first handed it to the process server to go serve the defendant. And so, Your Honor, the really relevant time period for this court to really look at is between December 18th, 2023, the day that the citation was emailed to the plaintiff counsel record, and the date that they finally gave it to the process server on January 19th, 2024. That relevant time period is what we're asking the court to focus on. And in that time period, Your Honor, the evidence shows as plaintiff's response indicates, is that there was no due diligence taken in between that time. Now, they give a reason as to saying that it was an administrative error, and that administrative error is broken down in 3 parts according to their response. The first part of that was that, well, plaintiff's counsel record on file is not the attorney that was supposed to get it. It was supposed to be somebody else who was handling the service portion of that lawsuit, not the attorney of record on file. Well, Judge, if that was the case, why wasn't this other person on the server list accepting correspondence? They haven't explained to that. They were just saying, oh, it was an administrative error without even going any further. And the court clerk's office did exactly what they were supposed to do. They sent a citation to the counsel of record, to the attorney of record on file. And so by not a reasonable person, if he was going to be responsible for handling service, would at least told the court, hey, please put me on the service list. I'm responsible for handling citation and service. And so the court would have done that. The clerk's office would have done that, but that's not what happened. They didn't put Mr. Tackett, whose declaration is part of their response. He's the one who's responsible for that portion. His name has never been as counsel of record in this case, even to this day. He still hasn't made a notice of appearance. The second one was that the email sent on December 18, 2023 was overlooked by plaintiff's counsel because of an influx of emails during the holidays. There's nothing beyond more explanation as to what those influx of emails is. There's no indication as to how much emails that Mr. Brown received during that course of period, why that amount is reasonable for somebody to miss an email from the clerk's office with the citation. And it actually undercuts an admission that was in the response to the motion for summary judgment, Your Honor, in which if you go to paragraph 14, I'm sorry, no, you go to paragraph 14 of the response, Your Honor. It says on here, from December 18, 2023 to January 19, 2024, plaintiff counsel Brown checked email correspondence periodically during the holiday period, including Christmas and New Year's Day. So, Your Honor, the question begs is, if he was checking his emails periodically during that time period, how did he overmiss that email that was sent on December 18, 2023? And the part that really is hopefully fatal to plaintiff's response is that Mr. Tackett actually admits in his declaration, if you go to his declaration on paragraph 9, he says the time frame between receiving the citation on December 18, 2023, and then the statute of limitation on December 22nd, 2023 is 4 days. When I was waiting on the email returned from the clerk's office, Mr. Tackett admits he was waiting for that email to come through. It had already been sent, but he was waiting for it in that time period. The question that begs is, what happened on December 23rd, 2023? Did Mr. Tackett just stop waiting for that email? Or if he was still waiting for it, what did he do in response to that waiting for that when he didn't get it on the 22nd of December like he was waiting? Judge, they have not provided any evidence as to what Mr. Tackett did. There's not been one attempt at contacting the clerk's office saying, hey, what's the status of this citation? An ordinary prudent person, knowing that the statute of limitation had expired, would have had a sense of urgency. And so they would at least try to get this defendant served as soon as possible. And the first step would have been, hey, let's contact the clerk's office, find out what's going on with this citation. They did not do that. That is not in the evidence. And they're not admitting that they did that. There's been 0 attempts at contacting the clerk's office.
I've been here a long time, and I will say that the hardest time to contact the court is probably those 2 weeks at the end of December. I don't know if a lot of judges are gone, a lot of clerks are gone, you just have a lot of folks here out for the holidays. So I imagine that was probably part of it. Was that part of it, or?
Yes, Your Honor, it's a busy time for everybody.
Well, Judge, they haven't presented any evidence that they didn't contact it. They're not saying, hey, we contacted the clerk's office, nobody answered. We sent an email, nobody answered. None of that's been presented in the record for evidence, Your Honor. So from what we're seeing from the evidence, there's been no attempts at the clerk's office. And be that as it may, Judge, the first time they realized their mistake of overlooking that email was on January 19, 2024. Certainly, they haven't provided evidence as to why that email could not have been discovered after New Year's between January 1st and January 19th. We understand it's the holidays, but the holidays doesn't run through all the way to January 19, 2024, Your Honor. And so they haven't provided any evidence as to why they weren't able to discover that email before January 19, 2024. The third administrative error that they're pointing to, Your Honor, is miscalendering. They're saying, well, we didn't calendar the statute of limitations date. Well, Judge, Mr. Brown's a fine attorney. His lawyers in his office are fine attorneys. they're well aware there's a 2-year statute of limitations on personal injury causes of action. They're not arguing there's a tolling of the statute of limitations, so there's no, in-depth analysis to determine what that date is. They admit in their response that they knew about the statute of limitations as early as December 14th when they filed the lawsuit. In fact, if you go there on paragraph 5, it says, in an effort to effectuate service on Sonic within the statute of limitations, the same day following lawsuit, I, Mr. Tackett, who's not here, requested the Dallas County Clerk's Office to issue citation to the defendant. So they were well aware of the statute of limitations date was approaching when they filed the lawsuit. So this whole issue saying, oh, we didn't calendar it, so we missed it on our part, is really a non-starter, Your Honor. And so really, Judge, as a matter of law, that the court can find lack of due diligence either on if there's no valid excuse provided or the lapse of time and the plaintiff's inaction or action conclusively negates diligence, Your Honor. And the plaintiff's evidence clearly shows that. They sat on that citation without following up with the clerk's office, knowing that at least Mr. Tack was waiting for it. Go ahead. Thank you, Judge.
Thank you, Your Honor. Would you like for me to stand?
Whatever you like.
All right, thank you. Mr. Hunter Tackett was an attorney in my office. He got licensed in about October, and he was overseeing this group of cases in which this case was in. He filed it, or he filed the petition after my review. The citation was sent to me, and he was waiting to get the citations. Around the same time, in a separate case, it's not in my brief here, but I had another clerk who wasn't even an attorney, e-file something, and the court sent them the citation, never even sent it to me. So I instructed everybody, pay attention, this was in January when this occurred. Mr. Hunter was from Florida. Our office closed before Christmas and was closed for, I believe, 2 weeks, at least a week. And Mr. Hunter was in Florida, or Mr. Tackett was in Florida visiting his family. The administrative error is simply that one email in the amongst of who knows how many we get in this legal world now, got missed. As soon as Mr. Hunter returned, we were reviewing cases. We got to this one. Oh, he realized the service that they hadn't filed an answer or whatever at the time. We reviewed. I checked my email, found it there. We sent it on. At that time, process server tried 4 times to serve the registered agent. The business was closed every time. And then at that time, forwarded, I said, well, I in an attempt to get things done as fast as possible, we directed them to send it to the Secretary of State. After that time, the Secretary of State, mailed theirs off. The defendants then, we notified the insurance company said, hey, you guys are late. We've served, sent them return of service, so they could get an answer on file. We wouldn't take a default judgment against them. What I see here is that in the defendant's motion, the standard is not to show how many times you called the clerk's office. In the cases they cite, it's basically explain the lapse of time. What happened? And that's what I'm here to do today. The initial email was missed. It just got jumbled up in the inbox, and Christmas came, New Year's came. The attorney who's handling the case was out of the office for those 2 weeks, visiting his family. As soon as we reviewed, we got back on it and sent it to the process server. And as you can tell, when the process server got it, it was as quick as it could be. The defense is obviously taking a legitimate opportunity here at a summary judgment for something they see as service outside of the statute of limitations. And our explanation, our position is that it's a reasonable explanation to explain the lapse of time and the efforts we took and what we did, and what caused this lapse of time is because one email was missed while the other attorney was waiting on the citations that he had for the petition he had e-filed. The attorney's office was closed, and the attorney overseeing the case was out of the office for even longer than that. We have the Christmas holiday, New Year's holiday, and it seems to be several reasons there to describe or to explain this lapse of time. And all we can do at this point is explain to the court what happened And that's why we're here today. So that's all I've got, Your Honor.
Judge, if I may.
No, I'm good. I'm gonna deny the motion. I will say this to you is that, I've been practicing a long time. Back when I used to respond to these kinds of motions all the time. The law is getting more difficult for plaintiffs, and so, I'd urge you in the future to be, careful about waiting till right before the statute of limitations to, file lawsuits. You should try, obviously this change in the law is making it riskier to do that. And so, I urge you to be careful about doing that because you kind of put yourself in unnecessary, harm's way. But I think in this case, there is due diligence, and, you have a proposed order for me.
Now, approach, Your Honor.
Yes. Yeah, you'll be able to get this. All right, guys, anything else today?
That's it, Judge.